The State of Crypto is presented by Tron, connecting the world to the power of cryptocurrency.
Welcome back to First Mover. Florida Governor Ron DeSantis signed a bill last week prohibiting the use of central bank digital currencies in the state, but some legal experts say that may not amount to much on paper. Joining us to discuss is Carla Reyes, Southern Methodist University Dedman School of Law assistant professor. Welcome, Carla.
Hi, thanks so much for having me.
Of course, thanks for being here with us. Why don't you start off by telling us your thoughts on Florida and other states signing this into law?
Yeah, so my first thought is that it doesn't actually prohibit the use of central bank digital currencies in Florida. That's not what it does. So to start, back up a bit and explain why that's true, the Uniform Commercial Code provides rules for parties who enter into voluntary transactions. So when parties voluntarily choose to enter into certain transactions like sales or secured transactions, then the UCC provides the rules to help them predictably know what their rights and responsibilities in those transactions are, even when the transactions cross state lines. So the first point is the UCC is private law that enables voluntary transactions by private parties. It does not force anyone to do anything. And conversely, it cannot ban anyone from doing anything. Isn't that what it does? Second of all, the way the bill is written, it does two things substantively, the words. First, it defines the term central bank digital currency in a way that, in my view, is not terribly helpful. It specifically says it's a non-technology neutral definition, and it specifically says it applies to central bank digital currencies that are issued directly from the government, whether it's foreign or domestic, directly from the central bank to the consumer. And today, there aren't very many, if any, central bank digital currencies that exist that do that. So effectively, the central bank digital currency term as defined in the Florida law does not cover central bank digital currencies that exist. So it hasn't prohibited anything practically. Secondly, yeah, do you have a comment or question?
Yeah, constitutionally, can Florida pass this kind of a law if you consider that, in the Constitution, there's rules on contracts that, the laws can't get in the way of contracts between private citizens as long as they're, for legal things, obviously. But, can anybody get in the way of a contractual obligation that one party has to have for another in exchange for something?
Well, so I'd say first they can pass this law because they didn't actually get in the way of anything, which brings me to the second point. They didn't prohibit anything. They excluded this badly defined term from the definition of money in the Uniform Commercial Code. And that is not the same thing as saying that you may not use central bank digital currency in Florida. That's not what happens when you exclude the term central bank digital currency as defined from the definition of money. So, for example, if the transaction at issue is a secured transaction, all that means is, so say you wanted to borrow money from me and you wanted to use central bank digital currency as the collateral. And you say, if I don't pay you back, then you can take my central bank digital currency to satisfy the loan the obligation to pay you that I owe you. And all that excluding the definition of money, excluding CBDCs from the definition of money does is tell me that it's not money. And so I look to a different classification in the Uniform Commercial Code, like what is this thing? And it could be under Florida law right now, even after this law has been passed, it could be a general intangible, or depending on how you hold the central bank digital currency, it could be, I could treat the collateral as a deposit account, or we could agree voluntarily to opt into Article 8. We could treat it as investment property and hold it in a certain way. And in either of those three cases, I know what to do to perfect my rights and responsibilities and to facilitate that transaction. We can still use central bank digital currency in that transaction. Nothing has been prohibited. And so in that regard, yeah, he can pass the law. Florida can pass the law and do that because it doesn't interfere with the contract. It just changes the way that I have to conduct the transaction. That's all. But it actually doesn't prohibit me from doing anything.
It sounds like what you're saying is, the public message versus what's happened on paper are very different. What do you think is the motivation behind this public message, the saying that we are banning CBDCs that could potentially be issued by the federal government?
Yeah, so I think the motivation is that there are concerns about central bank digital currencies and the privacy implications of them. Frankly, policy concerns that I share as a personal matter. And I've heard commentary recently that, well, at least the Florida is raising the issue to the national discussion. And while I appreciate that sentiment that at least people are talking about it and now people are aware of the privacy concerns related to central bank digital currencies, I actually think that there's substantial harm that can happen from tying central bank digital currency discussion to the Uniform Commercial Code. The first of which is that the message to the public is, look, we fixed it. We banned central bank digital currencies in Florida. And the result will be that the policymakers and the constituents are going to think, well, we don't have to try and do anything else to combat central bank digital currencies because we fixed it in Florida. No, it doesn't apply to us. And that's simply not the case as a factual matter. The second part of the potential policy harm is that this is connected, I think, to the broader discussion across the United States about the Uniform Commercial Code amendments, the 2022 amendments, and Article 12, and this notion that the Article 12 amendments are designed to make a way for central bank digital currencies to be a backdoor to encourage it, which is not at all what they do. And rather what Article 12 does is put Bitcoin and other cryptocurrencies on equal legal commercial law playing field with other forms of payment. And so my concern is that when we tie the anti-central bank digital currency discussion to which, and I think, to be clear, I think there are real deep privacy concerns there that we should care about. But when we tie it to the Uniform Commercial Code, which is a vehicle completely inappropriate for that discussion because it doesn't ban or force anybody to do anything. It's not regulatory. It's private law. When we do that, we also discourage people from adopting Article 12, which is incredibly beneficial to the rest of the Bitcoin and cryptocurrency ecosystem and commercial law. And so although I think the motivation to get people to think about to actually protect privacy when it comes to a concern about central bank digital currencies, well, I think that's a real concern and a valid policy concern. I'm very, very concerned about tying it to the UCC because I think it has substantial harms that it's causing.
Do you anticipate CBDCs being politicized coming up to the next election?
I think CBDCs are inherently politicized, frankly. I think that it's those concerns around privacy and, whether you're concerned about financial privacy tend to be political issues, right? On the one hand, you have you don't have anything to hide. What do you have to worry about, right? And on the other hand, you have valid concerns about not wanting everyone to see everything you're doing with your money, right? And I think those are genuine policy issues that tend to divide along political lines. And I don't see anything inherently problematic with that. What I do think, and maybe it's not problematic, but what surprises me the most is that it's the UCC that is being politicized and that is sort of rising to the debates. Because as a commercial lawyer, I can tell you that's not a thing that we thought would ever happen in a million years. When was the last time you thought about the UCC until this happened? That you even was oh, there's a Uniform Commercial Code? Right? Not often, unless you're us. And so anyway, that's the most surprising.
So Florida,
Carla,
strong on privacy with money, not so strong on privacy when you use the bathroom. Okay, well, in that case, thank you very much. That was Southern Methodist University Dedman School of Law Assistant Professor Carla Reyes.